Welcome to the Truth About False Confessions podcast. I'm Alan Hirsch, chair of the Justice and Law Studies program at Williams College and an expert on false confessions. To learn more, visit my website, truthaboutfalseconfessions.com. Now on to today's episode. Because I typically work for the defense in criminal cases, I'm often asked whether I would assist someone who I think is guilty. The answer is yes, under some circumstances. For one thing, in the court of law, my opinion about the defendant's innocence or guilt makes no difference. Few judges even allow me to express that opinion. And as I have been painfully reminded too many times, just because I think someone is innocent does not mean a jury will agree. Why should my feelings in the opposite direction, that the defendant is guilty, be any more decisive? Is it fair to a defendant if I decline his attorney's request for assistance because of my fallible opinion about his guilt? On the other hand, while my opinion could be wrong and will not by itself determine the verdict, why should I do anything that I think promotes injustice? Why help an attorney convince a jury of something I don't believe? These are fair questions, but they may reflect a skewed perspective. When I testify, I make my assessments under penalty of perjury, and I never say anything I believe to be false. The jury is entitled to hear from any witness, expert or otherwise, who either party wishes to call and whom the judge believes has relevant testimony to give. While I may think a defendant is guilty, it hardly follows that the jury should not learn about the risks of the interrogation tactics used on him. Moreover, as a practical matter, if I tell an attorney that I do not wish to testify, he could subpoena me and force me to. If an attorney thinks I have something of value for the jury, why make him go to the trouble of a subpoena? In addition, there is a difference between thinking someone is guilty and knowing it. Should I help a defendant who I am certain is guilty? This question does not often come into play because I am rarely certain. As I know all too well, confessions may be false. Eyewitness testimony, too, is notoriously unreliable. Not even DNA evidence is infallible. In the case with the proverbial smoking gun, the defendant typically pleads guilty. Without the smoking gun, we cannot be certain of guilt. But I do not wish to let myself off the hook so easy. There are cases where, if I were a juror, I would vote guilty with little hesitation. Moreover, my work does not typically consist solely of testifying. I also make suggestions to the defense attorney about ways to challenge the confession. For example, I often propose lines of cross-examination of the police officers who procured the confession. Why should I render such assistance when I believe the defendant is guilty beyond a reasonable doubt? The case of a man I'll call John Doe, charged with sexually assaulting an elderly woman, illustrates why I sometimes feel justified in assisting someone I feel pretty sure is guilty. One morning, Doe received a frantic phone call from his longtime girlfriend, Jane Doe. Apparently, the night before, Jane's sister, whom Doe knew well, was assaulted in her house. The culprit wore a mask, and she could not identify him. Shortly after hearing about the crime from Jane, John Doe left town, flying across country, for no apparent reason. When he returned home, he checked into a hospital, seemingly dazed, and expressed concern that he had suffered a stroke. But the doctors determined he was okay and released him. The police summoned Doe to the station. In the video interrogation that followed, John Doe appeared dazed. Questioned gently by detectives, he could not explain why he left town, and he struggled to answer basic questions like where he lived and worked. After an hour of establishing a rapport with Doe and gathering information, the officers excused themselves from the interrogation room. Upon their return minutes later, their amiable questioning gave way to aggressive use of the Reed technique. They claimed to have absolute undeniable proof of John Doe's guilt, a position they maintained for the duration of the interrogation. They made various false claims about evidence allegedly establishing his guilt, including the notions that surveillance cameras showed him entering the victim's house and that testing revealed the presence of his DNA on the victim. The detectives accompanied this standard Reed technique confrontation with extensive minimization. They suggested that the victim provoked John Doe's assault. "She must be lonely. Maybe she came on to you," one officer said. They proposed that the assault was a spur-of-the-moment thing and suggested that Doe made a mere mistake, and they wanted to help him. At one point, the officers indicated that all they wanted from Doe was an apology, an extreme form of minimization. Despite the relentless interrogative pressure, Doe did not confess. However, at various points, rather than insisting on his innocence, he said he could not remember committing the crime. When that happened, the officers should have stopped confronting him with certainty of his guilt. Even Reed and Associates admonishes interrogators not to persist in accusing a suspect who, rather than proclaiming innocence, says he cannot remember. To persist is to run the risk of an internalized false confession where the suspect actually comes to believe he may be guilty. Ignoring this prudent restraint, the officers continued to express certainty of Doe's guilt. What took place to this point was therefore worse than a typical Reed technique interrogation, but it was not terribly unusual. What happened soon thereafter, however, was unprecedented, at least in my experience. It was set in motion by something common. John Doe requested a lawyer. That should have ended the matter. Under Supreme Court law, the officers had to stop questioning Doe. They did so and left the room. But before long, one of the detectives returned, accompanied by Doe's longtime partner, Jane. Now, while ostensibly talking to her rather than to Doe, though with him seated a few feet away, the detective resumed the Reed method. He again implied that Doe's DNA was found on the victim and that cameras showed him present in her home. He again engaged in minimization, suggesting that Doe was drunk or acted on a whim. At one point, Doe interjected to say, "You said you'd help me. You never said how." This statement suggests that the officer's minimization, specifically the offer to help, had gotten Doe's attention. The detective responded that he could help Doe if Doe confessed while attributing his actions to alcohol. Then he reiterated that he could not talk to Doe because Doe asked for a lawyer. The detective also stated that unless Doe confessed and raised a mitigating circumstance, all they're going to see is a predator. Again, standard Reed technique. But after Doe had unambiguously requested a lawyer, no questioning, Reed or otherwise, is permitted after that. In my 20 years of work in this field, during which I've viewed hundreds of interrogations, I had never seen or even heard of this tactic. The police evading a suspect's Miranda protections by using the Reed technique in discussion with a third party, but plainly for the purpose of eliciting a confession from the suspect. Shortly thereafter, the detective again stepped out of the room, though of course the camera kept rolling. Left alone with Jane, John Doe proceeded to make tentative admissions of guilt. When she asked, "Do you think you got drunk and went crazy?" he replied, "I think I did. You know how the drinking affects me." But he still maintained that he remembered nothing about his alleged actions. A little later, he and Jane were joined by Jane's daughter. Doe now made additional admissions. At one point he said, "It's a bad thing, an accident, should never have happened." Jane explained to her daughter what she believed happened based on what Doe had told her. "He got drunk. He took my car. He broke into the house. He was drunk and didn't know he did it." She went on to describe Doe's state of mind. "I don't remember, but I know I'm guilty." Doe, who was present when Jane shared this version of events, did not dispute it. The case fit within the customary pattern of internalized false confessions. Confronted with allegedly objective proof of his guilt, Doe, who distrusted his memory because of his history with alcohol, made tentative admissions of guilt based on inference, "I must have done it," rather than recollection. But that did not mean his admissions were false. There happened to be compelling circumstantial evidence of guilt, starting with Doe's mysterious disappearance, which he could not explain, the day after the crime. The victim said that the culprit carried handcuffs. Doe's daughter told police that he kept handcuffs in the garage of his house. When the police searched the garage, they did not find the handcuffs. In addition, Doe had fresh bruises on his forehead that he could not explain. I believe Doe was probably guilty, but his lawyers wanted me as a defense witness. They turned out to be superb attorneys who did a surprisingly strong job neutralizing the circumstantial evidence. To take just one important example, they managed to get Doe's post-crime flight kept out of evidence. With the benefit of my testimony about how the circumstances of this case checked many of the boxes of an internalized false confession, they thought there was a realistic chance of an acquittal. Caught up in the adrenaline rush of a trial, they were excited by the prospect. They understandably wanted to win the case regardless of whatever doubts they may have had about their client's innocence. I found myself swept up in their excitement and rooting for an acquittal as well, but not without reservations, which increased when I took the witness stand. Sitting in the first row of the courtroom gallery, in my direct line of sight whenever I looked toward the attorney questioning me, was a large man with a cross between a scowl and a smirk on his face the entire time. If expressions could talk, his said, "Go ahead, Professor, spin out your fancy theories. You know that the bastard you're helping is a rapist." Over lunch, after I finished testifying, the defense attorneys informed me that the unnerving spectator was the victim's son. I certainly cannot begrudge him looking at me with disdain, and I'd be a liar if I said that his feelings in retrospect didn't bother me. The jury found John Doe guilty. I felt conflicted. On the one hand, as I said, I had gotten swept up in the excitement of the defense trying to win the case. On the other hand, after the feeling of disappointment wore off quickly, I felt somewhat relieved that justice was done. In terms of the larger ethical question about my willingness to assist the guilty, I feel no compunction about testifying in that case, and that would have been true even if the jury acquitted Doe. What he did to the victim, which was horrific and I would never minimize, was a single act. What the police did to him, while unique in its particulars, was part of a faulty system that destroys the lives of numerous innocent people on a regular basis. And if nothing else, I got to educate 12 members of the community about false confessions and abusive interrogators. Thank you for listening to this episode of the Truth About False Confessions podcast. I would greatly appreciate it if you would rate the podcast on Apple, Spotify, or whichever platform you used to listen.